All right, welcome back. Welcome back. How's everyone doing? Everyone doing well? Good, 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 good. No one sits in the front row. It's interesting. Everyone's kind of clustered in the back. Don't be afraid. I come in peace, okay? Or perhaps I'll leave you in peace. I'm not sure which one. All right, so how's everyone doing? Have a nice weekend so far? Very good, very good. Any questions on adverse possession? Anything on your minds? Any questions on adverse possession? No? Yes, sir.
I've got a good question. Something I was thinking about actually this morning.
Okay.
So I know.
Right? And you both own the place, and he's there for 10 years. Can he kick you out? No, because you owned it together, right? You have to have exclusively. So he wasn't there for 10 years. All right. Any other questions on adverse possession? This.
Follow up on that. I'm
Yes.
doing something where if you have like co-owners, one owner could the owner out if you gave him like some kind of notice or something like that.
Right.
Stating his intentions.
Well, sure, right. So say you have a roommate, right, and your roommate throws you out because he doesn't like you. Okay. You then go to a court and say, okay, I have a right to be here. Let me back in. Right. Unless you go out and let him be there for 10 years and do nothing, you'll be returned to your premise. Only if you do nothing for 10 years, you let him oust you and does something for 10 years. Good. Any other questions on adverse possession? Okay. It's kind of an odd topic. It doesn't really fit anywhere else. And probably in an ideal world, you do it in Property 1. I don't fully understand why you do it in Property 2, but that's how it's been done for longer than I've been here. So that's where you guys are going to learn it. We won't come back to this at any point until we do something called a prescriptive easement, which you've already.
Financial documents, you know, your income, tax returns, and the bank will then notify you how much they will lend you.
Okay.
And that's sort of your budget.
Okay. And after you pre-qualify, did you ever have any problems with the closing of the arrangement?
Not related to finance.
Okay. Now, did you work with a lawyer?
Real estate agent and title company.
Okay, so you didn't hire a lawyer. Okay. And were you the buyer or the seller or both?
You know, both.
Okay, very good. I'll come back to you in that question. Is that Aaron?
Yes,
Aaron, you said you bought a house?
I'm buying one now.
Oh, perfect timing. So you want to tell us about your process?
We sold our house about 2 weeks ago, went under contract. Tomorrow ends the 10-day option period.
Okay.
We close on the 18th.
Uh-huh.
On our house, the house we're purchasing, we close on, I think, the 24th.
Okay, so you set up that the house you're selling will close, and roughly a week later, the house you're buying will close. Is that deliberate? Very good. And have you had any problems with the inspection or the place you're moving into or anything like that?
Not yet. We did have the market, we had the house on the market for a while, and we actually had 3 different offers, and the previous 2 fell apart.
How'd they fall apart?
Well, one of them, the woman was in the middle of a divorce, and she lost her finances.
Okay.
So she was unable to close. The other one, they ended up picking a different house. They put actually 2 options out, and they pit us against each other. It was kind of insane.
Interesting. And did you work with an attorney in either deal?
My husband's in.
Oh, okay. Got it. Okay, very good. And Catherine, well, you have any experience with buying a house?
I'm a licensed real estate agent.
Oh,
So,
welcome to this class. Thank you very much. I love having realtors in this class.
I don't have anything to add.
Yeah, I mean, once I had a property, one had an oil and gas expert. I was like, perfect. Okay, so you've done buying, selling, everything. Okay, very good. We will come back to you at some point this class. Anyone else have any experience with this stuff? Okay, I haven't. I've never actually bought a house, but I will do my best to recreate what it takes because it's fairly routine, right? Right? Unless something horribly goes wrong, very basic things have to happen. And the book provides a pretty decent overview. So in case you haven't done this before, effectively the first step, and I think Jeff spoke to this, is that as a buyer, you need to decide how much can you spend, right? How much you're actually looking to spend. And this isn't some sort of fictional inquiry, right? You need to actually go to the bank and say, okay, bank, how much of a mortgage are you willing to give me to buy a house based on your credit history, based on your income, based on your assets, based on your debt? And the reason why this is important is obvious, right? If a bank won't write you a mortgage for a house of a certain price value, you have no shot of buying it, unless you have cash, right? So Catherine, how often people walk in with cash, a couple $100,000 like in a suitcase, right, and just hand it over? Does that ever happen?
Yes.
Okay. How often does that happen?
It's extremely rare that it happens.
And is that like are you suspicious when that happens?
Not at all.
Texas, okay. Really? Okay. Well,
No. I mean, some people,
they just walk in with a suitcase like, all right, deal?
some people have money in the bank.
And when they walk in with
It's not even a suitcase. The bank wires the money. It never
I said suitcase.
you don't put it on a table and stack it up.
I said you're bringing a suitcase of cash.
It's just
With that, okay. You ruined my
Sorry.
That's okay. No, I'm saying a suitcase full of cash. That's a lot of bills. Anyway, so first you have to pre-qualify, which is what Jeff said a minute ago, right? And your bank gives you a letter or something saying you qualify for X amount. Is that basically right?
Yeah.
So when you go to a house you're looking to buy, say, okay, look, here's the letter. I pre-qualify for, let's say, $200,000. And that way they know that you're a serious contender and you're not just, wasting their time. Okay? So then you have your pre-qualification, you find your property. Now, did you look on your own for property? Did you use a listing service, or how'd you find it?
Combination of both. Mostly look on our own.
Okay, Aaron, same?
We've done both. My husband acted as the real estate agent because we've also an agent and broker.
Mm-hmm.
And then I convinced him he was too busy, so we had an agent.
Was that a good decision?
It was an excellent decision.
You should hire Catherine. Perfect. No. Okay, very good. All right, so after you actually find your property, you have to discuss the actual negotiation of the price and negotiate what are called contingencies. Now, did you have any kind of contingency issues that came up in your deals?
Yeah, we're waiting for the option to end. She could show up with anything within the next 24 hours.
You have anything that popped up?
Not that I can think of.
Okay, so Catherine, generally, what are contingencies? What are these kind of things that come up that people buying houses should be aware of?
The biggest one's probably going to be if financing falls through or you can't get it.
Okay.
But it's a contingency, as in, you'll have an exclusive option to purchase contingent upon, like getting your mortgage approved from the bank, or contingent upon the inspection report. It's during your option period.
How often does it happen that someone comes in with a letter saying they're pre-qualified for a mortgage of X and then it falls through? Or why would it fall through? The bank pre-qualified them for X, but then whatever happened.
The property may not inspect. The bank may not be satisfied with the results of the inspection.
Sometimes the bank says no.
Right.
Interesting. Okay. So after you've had the negotiations and everything else, you should probably consider a title search, right? And Jeff, you mentioned title search. What is this title search? How'd you go about doing this?
A lot of that was just handled through the title company.
Okay. What does the title company do?
They will search the title, make sure that, or at least they'll report what liens might be on the title. Make sure that the person has a clear title.
Okay. Very good. So we will do title search at great, in fact, painful length later in the semester. But effectively, you're looking into the history, or maybe we call it the permanent record of a piece of property, right? Who owned it before? Did they have any, perhaps, what he said, liens? Are there any encumbrances on the land? Does someone else may have a claim to it, right? Has anyone else perhaps had a mortgage on it, right? These are the things that you need to know before you buy a piece of land, right? You're not required to do a title search, but if you don't, you're pretty stupid. And the failure to do something can be, do people ever not do one in your experience?
No, never.
Yeah, so effectively, virtually everyone does a title search. They're not very expensive. They don't take, unless if that's really old, but
they're super important.
Yeah, they're extremely important, okay? So after you get the financing done, after you get the title search done, after all the contingencies come up, you have something called closing. So you remember last year from Property 1, livery of sizing, right? Remember the thing where you take the clump of dirt and you put in someone's hand? This has very deep significance. So the actual closing is where you literally give the key to the other person, right? And this is what's effectively the livery of sizing. You are transferring ownership. And in some states, I don't think Texas, you actually require the buyer and seller to be present. Not in Texas, right?
They don't have to be present.
Their agents can, right?
Time.
Right. For example, in New York, buyer and seller must be present, and you actually have to have the buyer hand it to the seller, which becomes very expensive if you're living out of town or out of the country or wherever else. Okay. And once the closing happens, you have a done deal. You are now the owner of a property. Right. That's the general overview. Any questions on that? This is not the hard stuff. This is going to be one of the lighter classes today, so you can just enjoy that much at least. Okay. What actually matters, though, is what's often called the contract of sale. Okay. And I linked, it's a little small, but if you go to the class lecture notes, there's a link here to the Texas Real Estate Commission residential sales contract. You're probably very familiar with this. Okay. It's a very simple PDF, about 9 pages long. And you can go through this when you have a minute, but this is meant to standardize the process of buying a single to 4-family home in Texas. Even if you're not represented by an attorney, you can more or less figure out the various things that you have to fill out. I'll go through the one in your book because it's a little bit more detailed, but we'll come back to this one later. Okay. One thing just to stress, though, you might remember when you study contracts, at some point, your professor probably said, contract law does not apply to sale of property. Remember this? You should remember it, right? The UCC applies to goods and services, right? Not property, okay? There are some similar terms, which we'll be discussing today, that may sound familiar to what you did in contracts, but they're not the same, okay? So we'll use similar words, but just remember, contract law doesn't govern property law. So last week when someone said consideration, I'm like, okay, Josh, don't beat up on her yet, but we have a very different system of laws that we have to use, even though they're very similar terms, okay? The other thing about property that should drive you nuts by now is that there's no UCC. There's no nationwide standard for property law, right? So if you study contracts in Texas and you go to New York, California, contract law will be virtually the same. You know, maybe a few differences here and there, but for the most part, the UCC is standardized. Property law, no. And in fact, I'm sure as Catherine will attest, the training they have to go through to become a real estate agent in Texas is probably very different from that in other states. There's a lot of different laws you have to learn. Yeah?
I don't know what it's like in other states.
It's different.
I imagine.
Yeah, it's very different. Okay? So in terms of the elements of a contract, right, and I'll just list them, the things that have to be included. So one is the purchase price, right? Second, a description of the property, right? This is usually including a survey, right? Where is it located? Remember the case we did it on the Hood Canal in Washington, where all the properties are 50 feet over where they should have been. A survey is very important. Number three, and this one's very important. You have to have a good title, okay? And we'll discuss this more in a few minutes, but that basically means that the person selling it to you owns it, right? They actually have the power to convey it to you. And I can't promise you this enough, but I promise you again, on the exam, there will be a question where someone conveys a piece of property that they do not own. I promise you 100% it will be there, okay? Do not assume merely because someone's selling a piece of property that they own it. In fact, for my exam, assume they do not. Good assumption. Number four refers to various warranties of titles, right? We'll discuss warranties later, but these are various promises you make when you sell property. You're basically saying, I promise I'm selling you a good piece of land. If someone else comes along down the road and tries to take it from you, I'll defend you, right? These are different warranties or maybe guarantees you may want to call them. Number five, what's the date that you're transferring the possession? Okay. A couple minutes ago, Aaron said something like the 18th, the 24th, right? The dates are very important because this means by this date, set in time, everything has to be done. And if it's not done by this date, Aaron, what happens? You walk away. You walk away, right? Yeah. And when you walk away, that means the deal falls apart. So that's why people scramble at the time of closing. Number six, how do you handle proration? What's proration? Well, usually you pay your electricity bill a month at a time, right? What happens if Aaron moves in the 18th and there's still, you know, a couple weeks left of electric bill that's not paid? How do you cover that one? All right, that one's not too significant. Okay. What about furniture, personal property, and fixtures? So what is a fixture? A fixture is a piece of the house that's actually built in. So think of like kitchen counters, right? When you move, you don't take the counters with you, right? When you move, maybe it'll take a bookshelf, or maybe it'll take a bed, but you know, the stuff built into the wall, that stays there. So we have to talk about the actual fixtures in the home. Terms of escrow. So did you guys use an escrow agent? What did you use the escrow agent for?
So they would hold whatever funds toward the property.
What do you call those funds? What's that money you put down?
Mainly put down with your down payment.
What's that down payment called? How's it referred to in the reading?
Every down payment.
Nah, Aaron, you remember? All right, let's start going around. Where did I finish last time? Who was last? Okay, are you up next?
No,
Oh, okay, so this guy's up next. Josh, okay. Josh, what do we call that payment that you put up front? There's a term for it, which is used in the it's used in the readings. Do you remember?
I don't recall. Yeah, I can guess down payment.
No, that's not it. Do you have it?
I mean, I was gonna say like an initial offer.
No. What is it's a
Oh,
specific?
you said, like, specific.
Yeah, it's a specific term. It was in the script. So any questions on that? I'm going to walk you through a couple of the more important elements. The contract that they put in your book, you know, people ask me, what's the difference between the 7th edition of your textbook and the 8th edition of your textbook? This, okay? This is actually the biggest change in the entire book. The old contract was version 3.0. This is version 5.0. There's almost nothing different except for the ordering. They basically just rearrange stuff. This is the so it just drove me mad seeing what's where. But yeah, this is like the only major difference in the entire chapter with respect to what you're learning. Wonderful, right? Okay, so I want you to pay attention to a couple provisions, okay? So first on page 548 is paragraph 11. And I'm not going to make you read all of these. I'll just jump to a few of the important ones, right? This is a significant one because it involves the contingencies, right? This is basically saying if you don't get the financing in time, and it's like not your fault, right? For example, Catherine said the bank may decline, or something falls through that's not your fault. The contract's voided, and you get the return of your earnest money, right? This is significant because it allows people to negotiate in good faith. Think about it like this, right? If you let someone put down an offer on the house and you set a closing date, you have to take the house off the market. Someone else who could have come in off the street and made an offer can't now. So you have to make sure that if for whatever reason the deal falls through, you at least can let the deal cancel out and start over from scratch. Okay, don't worry about all this language, but this is generally an important provision. Okay. The next important one is on page 550, paragraph number 15. Oh, by the way, I'll stop with this one, right? Did anyone in Houston who lived near one of the bayous have a problem with flood insurance? No one? Oh, I'm glad. Actually, very good. But for those of you, I'm sure if you know, on Memorial Day, not too long ago, we had significant flooding here in Houston. It was so bad that the bayous, and by the way, I didn't know this, but bayou is the Louisiana pronunciation. Bayou is a Texas pronunciation. I had no idea. Bayou, go figure. Yeah, you learn stuff new, right? So, does everyone know how flood insurance actually works, right? I didn't know this. So there's a difference between water that comes from above and water that comes from below. So, right? Most of you probably have homeowners insurance or renters insurance, right? And if there's a hurricane and your roof rips off and all water comes in through the ceiling, right? That's covered by your homeowner's renter insurance, right? But what happened in Houston is not water from above. It's the bayous overflowed and it came in through the floor. Okay. You may not know this, but you cannot buy flood insurance for water coming up through the floor. Does anyone know why?
FEMA controls that.
What's that?
That's all FEMA.
Well, why is it all FEMA? Let's see if you can use your economics
Insurance
hat.
companies won't cover it.
Why won't insurance companies cover it?
It's too expensive.
Why?
Because there's a lot of floodplains that people build in,
Good.
and it's just
Good.
It's too expensive.
So let me ask you a question. Anything with that? Okay. So let me ask you guys a question, right? And I'm not teaching you for I'm not teaching you for con law, but you may have heard something called Obamacare, right? There's a connection, right? Generally speaking, people who are sicker are more likely to want to buy health insurance because they'll use it more. And before Obamacare, insurers could deny them coverage, right? There's actually a very similar principle, right? If you live in a floodplain, right? It says here, can't say it says flood hazard, top of page 549, right? If you live across the street from a bayou or across the street from Galveston Beach, right? There's a very good chance that you're going to get flooded, right? What if you live on the top of a very tall hill? There is no chance your house will get flooded. So the only people who ever buy flood insurance are those living where there's a risk of flooding. And if you're not living in a place with a risk of flooding, you won't. So what does that do to the insurance risk pool? Everyone in the pool is very risky and may require a significant payment of insurance money. So insurance companies say, screw this, you're like the sick person before Obamacare, we won't write you a policy. Does everyone know this, right? So that's why FEMA, the Federal Emergency Management Agency, we're on the 10th anniversary today of Katrina, who they did some good stuff there. they basically have to underwrite every single insurance policy for those who live in certain flood areas. So for many of the people living in Houston whose houses were destroyed, they can't go to Geico or Allstate and get a policy. They need to go to FEMA to obtain one. And many people didn't know this until the things happened. Yes, sir, in the back. That's is that Ryan? Yes.
If that's your flood, wouldn't that go also with like
Well, the difference is you can't predict where a tornado is going to hit, right? I mean, there's an entire chunk of the country where it can hit anywhere, right? In Houston, there's very specific places. Like you can actually look at the Houston Chronicle published a map. There are very specific areas that will flood and areas that won't flood. So if you go to the the Brays Bayou area, if you go 2 blocks from the bayou, there's no flooding at all, right? It's only right near where the banks overflowed. So those are the specific areas where no insurance company would write a policy. Yes, sir.
We effectively did do that in Texas. We created Texas Windstorm Insurance Association, which covers most.
Do you sell insurance?
I worked doing first-party claims for 4 years.
Yes. Okay, good. I love having people in my class know what they're talking about. Good.
So TWIA covers most policies, actually. So when you're buying from State Farm for, hurricane, windstorm insurance, it's TWIA.
It's what acronym are you saying?
Texas Windstorm Insurance Association.
Texas
TWIA.
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 Okay, whatever you say.
It
Yes.
is funded by the state of Texas, and probably going bankrupt if not there already.
Well, that's a problem with what's called adverse selection, right? When you write insurance policies for very risky customers, things go bankrupt. No, nothing more about Obamacare. We'll let that one go for now. Okay, wrong class. Anything else? It's funny. We actually do a surprising amount of Supreme Court con law cases in this class. The last 4 weeks of this class are on what's called the takings clause, which you might know as eminent domain. And I always get these comments saying, why is Blackman teaching us con law on property? Well, there's significant overlap between property and constitutional law. The entire nature of the government taking property is a constitutional matter. So hopefully I don't see those comments this year. But I always get these like, why is he teaching us con law? It's in the book. We're learning it here. Don't worry, I promise. Okay, any other questions on that? Go on to paragraph number 15 on the next page. The deed. Actually, 15 and 16 will have them both on the screen, okay? Number 15 is probably the most important paragraph in this entire, I'll make it bigger, most important paragraph in this entire document, okay? Where was I up to? Okay, I'll go back to, okay, so sorry to you again, Josh. Josh, you do know the answer. All right, Josh, so do you remember something in contracts? Get an implied warranty of merchantability. Does that sound familiar? Do you remember roughly what that was? I don't need the details.
It's essentially that the good that you're buying is suitable for the purpose of what you're buying it for.
Exactly, right? In contracts, we have this idea of a marketable or merchantable. Marketable and merchantable are synonyms. It's the same word, right? The idea was, and I actually looked at these because I'd forgotten this, right? It has to conform to the buyer's expectations. When you buy a widget, it conforms what you think a widget would do, right? This is, elemental stuff. We have a similar doctrine in property, right? Your title must be good and merchantable. Same thing, basically. The title must conform to how you think a title of land should exist, right? That is, Jeff mentioned a couple minutes ago, there's no liens on it, right? There's no mortgages on it. No one has a claim to it. In other words, it's a good, clean piece of land, right? There's nothing that may bother you. So when you seller conveys a piece of property that has a good and merchantable title, you're basically assuring that it meets certain conditions. Okay? There's all the stuff that comes afterwards. For example, warranty, deed, and all this stuff. We'll discuss that later. But the key important word is a good and merchantable title. Okay? Now, I'm going to ask a question to maybe Catherine, because she'll know it. But Catherine, what's the difference between a title and a deed?
Gosh, I don't know the answer. Sorry.
Okay. People always get these two confused. It's okay, sorry. It wasn't in the reading, so it is unfair question. People often use these terms interchangeably, and they're not the same thing. Okay, so there's two words. So first, can everyone see this? Is this too big or make it bigger? Good, okay. When they installed the new projector, all my sizes got thrown off, so I'm not quite sure. I usually have a bigger font. Okay. So the title, and just put this in your notes because I promise you, like at least 5 of you will make this mistake in the exam. So just, no matter, even if I say write this down, some of you won't. Okay. Title is the legal relationship between a person and property. Title is a legal relationship between person and property. So when I say I have title to the land, that means I own it, right? It describes a relationship. Where you have title to a car, I'm sure many of you have a car more than a house, you own the car, right? That's your relationship. Now, what's a deed? Okay. The deed is the instrument by which title is transferred. And I'm going to put in parentheses a piece of paper. Okay. Why? A deed is just legal evidence or a document. The deed is the piece of paper, right? So when I convey title to you, I do it by handing you the deed. But the deed itself, the piece of paper, isn't the relationship to the land. I have title to the land, and the evidence of that is this little piece of paper, this deed, right? Everyone understand that? So when I say what's someone's title to a piece of land, I'm not saying they own it with a piece of paper. I'm saying what is a relationship to it. If I want to say I want to sell it to you, I'm going to hand you the deed, and the deed is evidence that I'm transferring title to you. Everyone get that? Don't confuse those. People, I mean, even I promise you, people will confuse that in the exam. Just don't. Just get this one straight, okay? Any questions on that? Yes, sir.
How does that apply to, for example, on a vehicle, you have a title, but not a deed? That title vehicle.
So right, so
people misusing the name.
Yes, right. So actually,
and then in Texas,
a car is personal property, not real property, so it's slightly different, right? But generally speaking, if you have a deed to your home, the deed describes your title.
Okay.
Right? Cars are personal properties. Again, personal property is governed by UCC. There's entire different. See, you're doing exactly what I said. There's similarities to contracts, but it's not the same. So when you use a term in one, it doesn't have the same meaning as in the other. Real property develops its own laws because property is so fixed, right? A car moves around, sells from one person to the next. Blackacre was in the same spot for 500 years, right? It's always in one state. It doesn't move around. So property did have the need to develop these kind of interrelated terminology. It's Texas law, Texas property. That's it. We don't have to care about other states.
So is it true you can't get a deed on single wide or double wide trailer?
I have no idea.
I've heard that you cannot because they're mobile. By definition. I
mean, well, yeah, if it's mobile, then it's not that's not real property. So I guess, yeah. I have no idea. You can look it up and tell me next class.
I'll ask my cousins.
In the back, sir?
So the title is just basically a long span of time. The deed is just a moment in time that person transferring it.
Yeah. It's the deed is just proof that you've transferred title, right? It's a piece of paper.
So it's like the color.
Exactly. Color of title. Exactly. There's all these fancy words that effectively mean piece of paper. Yeah. That's why this class has a lot of stuff that you don't really know. Okay. And the last provision I want to turn to is on page 557. That's paragraph number 41. See, I told you I breezed through that. If you want, you can read through all of them. Most of them are not really necessary, but yeah, I mean, they added like 5 pages from this from the last edition of the book. I don't know why. Page 557. 1 second, let me get up here. Paragraph number 41. Okay. This one is actually significant and offers a nice seg into our first case. And this is the idea of dual agency, right? Is that Jack?
Yeah.
Jack, what's his dual agency business?
That's where the buyer and the seller use the same agent.
Okay. So we have this law called agency, right? I'm a principal and you're my agent, right? You serve my interest first. So generally, if I go hire an attorney, and as I hope in a couple of years you will all be lawyers, right? And someone goes to hire you, the client is a principal and you are the agent. And you have to put their best interests at heart, right? You can't self-deal, right? You can't do things that benefit you at the cost of your client, right? Everyone knows this. This gets a little funny, though, in property law. Because very often, if you're looking to buy a house and you go into a real estate agent's office and you think, oh, hey, wait a minute. I want to get to know Catherine, right? She'll be my realtor. I'm going to trust her, and she's going to trust me. And I'm going to give her information about what I want to buy. So that way, we can negotiate and get the best price from the seller. Catherine, do you have this happen a lot?
I haven't really sold residential real estate or been involved in it since like 08. So it's been a while, except for buying them.
Okay. Well, what usually happens, and I'll bring the Texas one up, it's actually a little bit better. I like the Texas one better for this one. And you can click on the link if you want to read it. But on the very last page, right? The very last page of the contract, it's a little bit small. Let me zoom in. You have to say, who is the broker, right? And who does he represent? Check. Does he represent the buyer as the buyer's agent? Or does he represent the seller as the seller's agent? I'm sorry, as the broker's sub-agent, right? Which basically means the seller's agent. Why is this important? The reason why this is important is, generally speaking, the person who you think is your broker is actually working on a shared commission with the seller. I said that again. The person who you think works for you is actually working for the seller. So any personal information that you give to the broker, that broker has a duty to pass it on to the seller. So let's say you tell your broker, I cannot go above $100,000. That's my absolute limit, right? That agent has a duty to tell that to the seller. Now try negotiating with someone who knows all of your secrets. It's not very effective, right? That's why under this form, Texas says you have to check. And by the way, this is actually very nebulous. Seller as listing broker subject. What the heck does that mean, right? But it basically means that person doesn't work for you, right? This one's a little bit more clear. Seller as agent, right? That makes it a little bit more clear. So you have to be careful when you're working with a seller's agent to say who they're working for. Now, in recent years, something called a buyer's broker, right? And this is basically a broker who works only for you, right? You are his client. There's no divided loyalties. I actually had a student a couple of years ago sat right there who was a buyer's broker, right? But you want to know what the problem is with a buyer's broker? Anyone know? They don't get paid. Why don't they get paid? Who said it? I heard a voice. Why don't they get paid?
Because basically they're taking a cut from the transaction. House, and it's, unless they contract with the buyer, they don't have to include. They're not included in that transaction.
Exactly. So usually how it works is like this. The selling agent takes a 6% cut, and 6% is just an easy number, right? He'll split that with the buyer's broker, right? So basically the seller's agent and the buyer's agent will split the fee because they're working together. But you have this other guy on the outside, the buyer's broker, he's not in privity with them. He doesn't have a relationship with them. So the student right there said he would never get paid. So basically they have to charge the buyer directly. And usually people don't charge for a buyer, right? They just walk in and they get whatever. So they're somewhat unpopular because they don't get paid. But there's always divided loyalties. Okay. All right. Any questions on those divided loyalties? Any questions on this dual agency business? No? Okay, let's do the first case then. Licari versus Blackwelder. And that's Jackson?
Yes.
Okay, Jackson. Walk me through. What happened? What happened in Licari? By the way, it's happened in Westport, Connecticut. And if you don't know where that is, that's the 10th wealthiest town in America. This is like where Martha Stewart lives. So this is a very, very wealthy area, which gives you a little bit of background of why there's some shenanigans going on. All right, so what happened?
So 6 brothers inherited property and they tried to sell it. And I think they
First of all, had these where did the 6 brothers and sisters get this land from?
from the parents.
Yeah, basically the parents were deceased, and the parents said, "We leave this property to our children." Okay, so let me give you a pro tip. It's very dangerous to leave any piece of property to 6 people, because it's unlikely that any one of them will agree what to do with it. I had one student who sat there last year, different room, but that seat. And he said he once had a piece of property that was left by his great-great-grandparents, right? And by the time 2015 rolled around, there were 40 cousins. And imagine if you have that big of an extended family. It was oil there. That's why it mattered, right? They found oil. So imagine if you had 40 cousins trying to fight over what to do with a piece of land. You can't decide anything. Some want to keep it, some want to sell it, some want to lease it. I mean, they were just fighting over it, and it went to court. So do not leave land with divided interest, because it gets very, very messy. And what often ends up happening, and this is the worst part, is that if one of the cousins sells his share to a very wealthy oil developer, he can just force all the other ones out by basically buying them out. So don't do it. Anyway, so they inherited the property with 6 people. What happened next?
They didn't know what they were doing, so they contacted the broker named Schwartz.
Okay. Well, yeah, okay. Good.
And then Schwartz went to, I think it was Blackwelder,
Mm-hmm.
to co-broker the sale.
Good. Okay. So basically, they did the right thing. They said, okay, you know what? It's going to be too difficult. Let's just sell the damn thing and split the proceeds, right? Just split the money up front. Okay, good. So Brandon, what happens after Blackwelder, the defendants, discovered, or learned about this property?
They realized that they could basically sell it for more than what the brothers were expecting.
Okay.
So they immediately made an offer again.
Wait. How did this go down? Because the way it went down is actually very important. You're right, but how did this transaction go down?
I'm not sure.
Will?
They bought the property 12 days later, they had already sold it.
No. How did the Blackwelders, or how were the Blackwelders able to make such a good deal on the land? How did they get that?
Because the 6 brothers didn't know the value of the land.
Well, that's true, but specifically procedurally, how did the sale happen to give Blackwelder such a good price? Spencer?
Didn't they convince them that it was that there was a real estate price of 125,000, and
Well, that's true, but procedurally, how did they able to make such a good killing on the price procedurally?
let's see.
You gotta
They
read
went
this
to the
close.
Westport brokers.
No.
Experience.
Jeff?
Um,
It's a very, very easy answer once you realize it.
I mean, they knew worth, but they had a buyer that they knew wanted their property. They were going to pay more than what. the agent-
That's all true, but what enabled them?
That they didn't allow for reasonable time period.
What was the time period? What was the time period?
24 hours.
A 24-hour, what kind of 24-hour period?
Negotiation.
Can anyone else intervene in that 24 hours?
No.
So what was it?
It's holding period.
What's that word? Anyone? Yeah.
It's an exclusive.
Exclusive. Okay, read the cases carefully. It's right there, right? They got a 24-hour exclusive negotiating period, right? Why in the world, okay, Nali, why in the world would anyone selling a house give someone a 24-hour exclusive negotiating period?
Because it's the exclusive.
Why would the sellers want to only give one buyer 24 hours and then no one else make a bid in that time? Why would they ever do that?
One buyer. Sorry. So, what's the question?
What's the benefit of a 24-hour exclusive period?
Maybe it should be quick.
Okay. Catherine, why would anyone agree to a 24-hour exclusive period? What's the conceivable benefit of that deal?
Money. If somebody bought like the 24-hour option period.
But is that generally a good idea to give one party a 24-hour option?
No, not at all. I mean, it's really strange.
So here we happen here, right? These 6 grieving children, right, just lost mom and dad, right? They've decided to sell their family home. This agent's, I got an idea, right? Give me 24 hours, and I promise you, I'll get you, maybe $125,000, right? Even if the value of the house was much more than that, they gave basically one party monopoly during that time period. Everyone see that? Okay. So is that Eric?
Mm-hmm.
Eric, so what happened during this 24-hour period?
Talked them down to 115.
Yeah. So, I mean, I don't understand what's going on here, right? They start at 125 and give them an exclusive negotiating period. They talk them down to 115. Usually you negotiate like up, right? If it's an exclusive buyer, right? And then what happened at the end? Did they make a deal?
Oh, yeah, they agreed to the 115.
Of course they did, right? And now, let's be precise. Who's they?
The siblings agreed to sell it to 115.
Who was the buyer?
The buyer was Blackwelder.
Exactly. And
He was
who
the
was
co-broker.
Schwartz working for?
He was a co-broker with Blackwelder.
Everyone see the problem here, right? Blackwelder and Schwartz were on the same team. Schwartz said, give my buddies Blackwelder an exclusive period to buy, even though they were splitting their commission. And this actually wasn't even the book, right? So not only did Schwartz get not only did the Blackwelder get the benefit of this deal, they actually got the commission on top of it, right? So this was a serious scam, and I'm sure they'd run this one before to a lot of people in the area, okay? Okay, so they buy the house. What happens next? Is that Tyler?
They turned around, I think it was within
Yeah.
like a couple of weeks, and sold it for $160,000, and they didn't disclose the information that they weren't buying it with the intent to occupy.
And who they sell it to?
Was that Opal or?
Who was he? The name doesn't matter. What was significant about the person they sold it to? Alejandro? Alejandro, what was significant about the person they sold it to?
Says that potential buyer neighbor was previously known to them.
No, just don't read. Tell me. What was significant about the person they sold it to?
I guess he had known beforehand they were going to buy it cheaper than selling it.
No. No, do you know?
The plaintiffs had instructed him not to contact.
Exactly. Okay, so here's what happened, right? Let's figure this out. Schwartz said, keep it open to Blackwelder for 24 hours, and they got a lower price than they expected. Shortly after Blackwelder acquired it, they had no intent of moving in. They flipped it, right? They sold it to, what's the name, Oper, right? For $160. They basically netted $45,000 in about 2 weeks. Good investment. And not only that, Oper was a neighbor whom the 6 children did not like, right? You know, he probably wanted to take the house, tear it down, build whatever. You know, who the heck knows? Like, he was a next door neighbor. So how many ways did the brokers mess up their clients, right? They recommended this 24-hour window, right? They suggested the price was much lower than it was worth. They didn't tell them that the buyer in this 24 window was working with them. Okay? After they sold it, they immediately flipped it for a profit, which they never told the 6 children about. And to make matters worse, they sold it to the guy who they said, do not sell it to. Right? This was a serious, serious violation of the interests of the 6 children. So what happened? They sued, right? They went to court. Is that Chase?
Yes, sir.
Okay, so Chase, what happened in the trial court?
Well, they wanted fraud. They didn't quite get to fraud, but they did find that they had breached their fiduciary duty.
Exactly. Good. What's a fiduciary duty?
You have to take care of their money.
Was that? I mean, you're right. But was that a fiduciary duty?
You have to make a good faith effort.
Whose interest comes first?
The brothers.
The client's, right?
Yes.
Okay. Fiduciary duty means you put the interest of the client first. Their interest, their money comes first, right? You can't self-deal, right? You can't put your financial gains ahead of theirs. And that happened here. They said, all right, we can flip this for 160. Make 45 grand. Cool, they'll never know. You can't do that. Okay? Good. So then what happened on appeal, Brendan? You know, Brendan? Will? I'm sorry. No, that's Tyler. Okay. It's Tyler. Go for it. Sorry, I skipped one row. So Tyler, what happened?
On appeal, they what's this case? The defendants or the brokers appeal?
So who lost in the trial court?
The brokers.
The brokers lost. Yeah, and they appealed. And what happened?
They lost again.
Yeah, they lost again. Why did they lose? What did the court find on appeal?
It wasn't a fiduciary duty.
I'm sorry?
They weren't acting in good faith.
Right. Why? Why did the court find they broke their fiduciary duty?
For all the reasons that we just went through.
Tell me again.
You don't want to go through.
Explain. Yes. Explain the court of appeals reasoning.
First off, they sold the line, got the land, sold it for cheaper. It was established.
No, you're right. Keep going. Yeah, you're good.
Okay.
You're good.
And then
I don't stop you. You're on the right track.
they set it up to where they could both get the money, and then resell it to the neighbor.
Exactly. Yeah.
Wasn't supposed to
Yeah.
have any right to it.
Exactly right. So we have here a situation where they breached fiduciary duty. Okay. This was the seller's broker, right? The broker was working for the seller. This wasn't the case we discussed a minute ago where the buyer gets screwed. The buyer can get screwed plenty, but the seller's broker can't screw him. Okay. Any questions in that case? Pretty straightforward. It sounds a little bit like what we've said in contracts with good faith and stuff like that, but the fact that it involved a piece of real property puts us in the property realm and not the contracts realm. Although there were plenty of footnotes in the restatement of contracts that you may have winced at if you saw. It's like, no cross-contamination, no contracts and property, right? Not so much. All right, any questions in that case? Not too difficult. Take a look at the questions on page, was it 563? Let me bring them up. And Will, just start reading the first question, paragraph number 1.
563.
563. I'll bring it up here in a second.
Is it the one that says broker fees and traditional brokerage fees?
No. Okay. 1 second. I'm sorry. Oh no, it's actually on page 563. 563.
Oh,
The problem. Yeah, here it is. Got it. So say, here's a problem.
Here's the problem. Suppose that selling broker B spends several months working with P, who's looking for residents with a white picket fence and a swimming pool. You got the search. P tells B that she is unwilling to spend any more than $870,000.
Okay, stop right there. Okay, so we have a situation, right? a selling broker is working with plaintiff for a number of months, right? And after working with him for a number of months, you have to think, oh, wait a minute. He works for me, right? He's on my side. So the buyer says, listen, I want a house with a white picket fence and a swimming pool. Okay? And the buyer thinks he's telling this to her in confidence, right? All right, keep reading.
B then starts a search for appropriate properties, diligently scanning the MLS listings. B subsequently finds a house with an estimated price of $899,000.
Okay, so we have here's a situation like this, right? That house is above her limit, right? So if you're negotiating, you're going to try and get the price down to $870,000, right? Will, does the agent have a duty to try and get that price down to $870,000?
No.
No, why not? That's correct. Why does the broker not have a duty to try and get that price down to $870,000?
Because he's working for the seller, not the
Yes. And so here's the difficulty, right? Try negotiating with one hand tied behind your back, right? Try negotiating where the person on your side is feeding all the information to the other side and saying, listen, his number is 870, right? You can't go any lower than that. So try getting a good deal. You won't be able to. So this is a difficult situation for a lot of people. Okay? All right. Straightforward, right? Any questions on that? No? Okay, again, I told you that. Yes, sir.
Will there be recourse for the seller if the broker convinced him to sell for $870,000?
Yes, and here's the rub. I'm glad you asked that question. What happens if the broker decides, you know what, I really like this buyer. I'm going to try and help him out. I'm going to conceal information from the seller. What do you think happens?
Again, because he's supposed to be working with the seller. So
Same as Licari, right? If you're a seller's broker and you withhold information from your client, guess what? You can get sued for malpractice. You have your license suspended. So even if he wants to be a good guy and says, I'm not going to mention this part about 870, I won't mention this part about the white picket fence, whatever, right? You get in trouble. So there's actually a duty to tell your client everything. Everyone get that? Okay, so moving on, the last part of our class for today focuses on a topic which I'm sure most of you think you never, ever, ever, ever want to think about again, which is the statute of frauds, right? Remember this from contracts? You burned it out of your minds? Okay, no. The statute of frauds is a lot easier in property than it is in contracts, right? The reason why is I don't care if something's inside or outside the statute of frauds. The reason why is because everything is. And I'll tell you why. This is the Texas statute of fraud, in case you've never actually seen it. Okay? And what it says here is that it applies for any contract for the sale of real estate or lease that is more than 1 year. So virtually every single property transaction that we have is subject to the statute of frauds. All of them, right? I do not want to see an exam. The answer is the statute of frauds does not apply because that would be wrong. Okay, I know that was the big thing. Contract, we always apply the statute of frauds. Understood? So once we get past there, it's actually fairly easy. Any sale of real estate must be, number one, in writing. And number two, signed by the party to be bound, or signed by the person to be charged with the promise. These are your only two requirements, right? It has to be in writing and signed by the party to be bound. Okay? Not difficult, right? And I promise this is much easier than you had in contracts. All right, so what does that mean? Any sale of real estate must be in writing, and both parties, buyer and seller, must sign it. Okay? There are exceptions to the statute of frauds, and there are two that we have in this class. Is that Rowan?
Armand,
How you say it?
Armand.
Armand. Okay. So Armand, what's one of the exceptions to the statute of frauds?
It's the part performance and stuff.
Oh, you give them both. Then perfect. All right. Well, go for the first one. What's part performance?
In the part let's say somebody relied on someone's core promise and he made some improvements on the land, or based on his reliance on their promise, he like does something like, you know, for which there is loss to him or something.
Mm-hmm.
So for that, the court will enforce the core promise. So that way the injustice can be avoided.
Exactly, right? These two doctrines, Armand just said correctly a second ago, part performance and estoppel, are grounded in equity. I'm sure you've studied equity in contracts and perhaps in torts. This is about fairness, not law of fairness. Everyone know how back in the olden days in common law England, you had the common law courts and the courts of equity? Everyone know about this? Okay. And in fact, in some states in America, you still have different courts. For example, in Delaware, you have the courts of law and the courts of chancery, or equity. Actually have separate courts and different rules and everything about them. Part performance means you enforce the contract even if it's not written, because people relied on it. And so the example is, what happens if, you know, I say to Armand, you know what? I'm going to sell you Blackacre, okay? And Armand gives me, you know, $100,000 cash in a suitcase, right? There's no writing. He just hands me over a briefcase full of cash, okay? And then he moves on to it and he starts living there. And then I go, hey, wait a minute, I never sold it to you. Well, I said I was going to sell it to you. He gave me the cash, which I have the cash, and he moved in. The actual acts, partial performance, get you around the statute of frauds, right? Usually the reason why we require a writing is to avoid, well, fraud, right? I say I sold it to him, and then I go back later and deny it. How do we prove it? It's a he said, she said game. But the act of him actually giving me the money and moving on to the land is sufficient evidence. Okay? And then is it Omar?
Yes.
Omar, what's the other one? Estoppel, he mentioned a second ago. What's estoppel?
That it's an unconscionable injury that would result in denying enforcement of a contract.
What, in your own words, what does that mean?
It's like it'd be something so unfair and unjust to somebody if we decided not to.
Okay, good. So you probably remember, do you do a case in contracts? Was it William versus Walker Thomas Furniture? Did you do this case? Okay, so you have a different book. Did you study unconscionability in contracts? Omar, do you remember like what was unconscionability, or what made something unconscionable? Anybody remember? Over there? Something like that, right? Yeah?
One side would proportionally, it's disproportionate gain on one side or the other. So one side is taking advantage of the other, in effect, what they're gaining out of the contractual relationship.
Yeah, something like that. It basically has to be something that's really unfair, right? Not just like one side got a bad deal, but it was so disproportionate, right? It was so unfair that you have to enforce a contract anyway. It will be unconscionable, which is a contract term used. Okay. By the way, let's think back to adverse possession, right? Is that Jimena? Let's think back to adverse possession, right? Let's like this. I say, I'm going to sell you a piece of land, right? And you hand me a suitcase full of cash. We never exchange any writings. And then you move on to the land and you're there for 10 years. Have you gained it by adverse possession?
Yes.
How come?
Because you have control of the land.
Hmm.
You've been there for 10 years. It's open and choice because you gave them the money.
Good. Good.
You've entered the land.
Good, good, good. Now let me give you a slightly different scenario, right? Let's say I say I'm going to sell you Blackacre. You give me, you give me a suitcase full of money, and then I hand you a deed, but I forget to sign it. And you have this deed, and it slips mine. I don't sign it. How long do you have to be on the land to get adverse possession? Well, what do you have? What's the significance of that deed? What happens if you have color of title? How long do you have to wait? Everyone see that? Remember I said you have a piece of paper that's fraudulent? That doesn't just mean a crook. I can give her a piece of paper, but I forget to sign it. And if we go back to the statute of frauds, it has to be signed by the party to be bound. So if I just hand you something that says deed on it and there's no signature, I have not bound myself. So very often what might happen with color of title is that they screwed up the transaction, right? They forgot to sign it, maybe the paperwork wasn't right, but because you have that piece of paper, which is that color of title, you now have the 3-year limit, not the 10-year limit. Comprende? Got it? Okay, not too hard, right? All right, any questions? All right, so Michelle, walk us through what happened in the in Hickey versus Green, please. By the way, this is where the Plymouth, the Pilgrims landed. Remember Plymouth Rock? Anyway. Go on.
Advertised for sale in 1980. The plaintiffs, Hickey and his wife, discussed purchasing the lot and entered into an oral agreement for $15,000.
Okay.
To convey the land. Ms. Green knew that he was planning on selling his house and building on her house once they conveyed. So she accepted a deposit check for $100, but never deposited it, didn't do anything with it. And then after the plaintiffs had sold their land in reliance upon the old agreement, she wanted to rescind the whole contract.
Very good. Very good. So here's what happened, right? You have old lady Green, right? She wants to sell her house. Hickey walks in and says, I want to buy it, right? They make a verbal agreement. Hickey gives to Green a $500 check, okay? He doesn't write anything in the, the pay to the order of line. And he puts a note saying subject to variance, because I think he might need some sort of variance from the zoning board, okay? But he signed the check, right? It was his signature on the check. Green takes a check and holds on to it. Okay, so let's just stop right there for a second, right? Natasha, is that check sufficient to satisfy the statute of frauds to convey the property? Just the check by itself. By whom? No. The lady, right? Exactly. Because the seller didn't sign it, she can't be bound. Go back. Look, right at the text of the statute of frauds. This is not difficult, right? By the person to be charged with a promise, right? I can say, I'm going to buy your land and give you a check, but unless you sign it, you as a seller, it has no effect. Everyone see that? Right? So you have a written instrument, but it does not satisfy the statute of frauds. Okay? All right, what happens, is that Peter?
Yes.
Peter, let's say like this. Let's say Hickey wrote a check to Green, and then on the back, Green endorsed it. She signed her name on the back. What do you think would happen there? No. I don't get to equity yet, right? Hickey said, I want to buy this house. I'm going to give you a $500 deposit check. I'm going to sign my name on the check, right? He hands it to Green. Green flips the check over, endorses it, writes your name on the back. What happens there?
What is being signed by the person?
Would that satisfy the statute of frauds?
Yes.
Yeah. You don't think about this, right? What do you think the purpose of writing a check is if both parties sign it? Oh, right, yeah. When you write someone a check, they put their name on the back, which means it's a mutual arrangement, right? You'll study this in other classes, a commercial paper and stuff. But originally, a check was basically to satisfy the statute of frauds. I'm giving you money. Okay, I agree to take that money, right? And that little memo, that's why you're giving the money over. This is the proof of the arrangement that you've come to. Okay? But here, Green never signed the check, right? Is there any requirement, Stephen? Is there any requirement for Green to ever sign the check? No, she doesn't have to, right? You don't have to sign one in your house if you reach a verbal agreement, right? Why? Maybe there was fraud, right? Maybe Hickey's lying. Maybe Green said, "Oh yeah, whatever, just give me a check," and she's like, "I'm gonna throw it out." Doesn't really matter. Okay. So everyone get the statute of frauds. Like the statute of frauds was not satisfied here because we did not have a writing signed by the parties to be bound. But then we get to equity, Stephen. What's the equitable problem here? Why is this problematic in terms of equity?
Because he advertised and sold his product.
And did Green know this? Yes. So here's the problem, right? Hickey told Green that I'm going to sell my house because I want to move in here. The same way Erin told us a few minutes ago that basically she sold her house and bought a new house to basically coincide, 1 week after the other. That's not uncommon, right? There's no sense owning 2 houses at once. In fact, it's probably impossible financially, right? Maybe you can. Maybe this guy owns like 10 properties, right? But it's generally expensive to try to maintain various properties at once because you have to have mortgages. And having 2 mortgages, you may not qualify for it. So it's not uncommon for someone to sell their house first and then immediately with the proceeds buy the new house. But for whatever reason, Ms. Green didn't care much for Mr. Hickey. So what did she do, Ben, after she knew the guy was about to sell his house in reliance on her promise?
She sold it to someone else. She was going to sell it to someone for higher.
Exactly.
16,000, and then the proceeds of selling the house, Hickey said, "We'll bid for 16,000," and she still said no.
Yeah. So some other guy came along, who knows why, right? And said, "Okay, I'll pay $16,000, $1,000 more." And she said, "Okay, deal." Hickey came back and said, "Hey, wait a minute, right? I already put my house up for sale. Well, what's going on? I'll give you 16." She's like, "Nah, too bad." And she basically probably ripped up his check or threw it out or who knows what she did with it, right? Okay. So, is that Caitlin? Caitlin, was Ms. Green bound to give the land to Mr. Hickey? Why do you say that? I mean, this was a holding of the case, right? What was the holding of the case?
Then yeah, she was. Sorry.
Yeah. Why? Why was she required to give the land to Mr. Or I'm sorry. Why was she obligated to give the land to Hickey?
Because the Hickeys relied on that oil.
What do you mean he relied on it?
Well, he sold their house. Based on their,
Good, right? So here's the situation, right? This is what we call detrimental reliance, right? Detrimental reliance. When someone relies on a promise for detriment, courts are unhappy, okay? Mr. Hickey sold his house based on the understanding that Green would, give him the property in a week or so, whenever it was. In reliance on that promise, he went up, sold his house, and then he was stuck. Okay? So as a matter of equity, yeah?
Well, Hickey seems kind of stupid because wasn't this just an empty lot? I thought it said.
Oh, it said lot S, actually.
So
yeah, it said empty lot, yeah.
He sells his house, and then he just buys this lot. Does he just kind of camp out? Like,
that's a good point. I didn't thought of that. It's a good point. Anyone else? Yeah. I mean, well, this actually comes up in the end, though. And I think the court realized this at the end, right? So maybe he had this genius idea that he would sell his house and build a new one, whatever, right? Or maybe he would camp. I don't know. But to say Mr. Hickey's stupid is probably a fair assessment anyway, because who would, on a verbal promise, sell their house? Yeah, this guy's shaking his head. Exactly, right? You don't do that. So because Hickey detrimentally relied on the promise and sold his house, the court says, equity says he should win, right? But it isn't that simple, right? Because a couple years have elapsed, right? Is that Alex in the back?
Yeah.
Alex, let me ask you, this is actually a general question, right? When a court of appeals, this is the Supreme Judicial Court, the highest court in Massachusetts, and for those who are curious, it's the longest serving court in the Eastern Hemisphere. It's been almost 400 years continual service, right? When the top court in Massachusetts hears a case, How long did it take for the case to get there? A couple years, right? Now let me ask you this question. Okay, a question. Can appellate courts ask the parties about facts that are new? Why not? Exactly. This is the thing which all lawyers make the mistake, especially appellate lawyers. The trial court is where the record is made. Okay? Courts of appeals can only consider what is in the record. You cannot introduce new facts into the case, right? Norma, why do you think that the rule is that you can't introduce new facts on appeal? Have you taken evidence yet, or are you taking it now? What? Why do we have rules of evidence? Right, and what happens if party A wants to do some facts and party B doesn't like it? What's that word? What are you saying, court?
I'm sorry.
Right. Objection, right? It's adversarial, right? You're in advocacy school, right? In the trial court, parties can fight over the admission of evidence, and the judges make a ruling on the record of whether something's admissible. Norma, on an appeals court, right? If a party writes some fact in their brief that was in the trial record, is an opportunity to object? No. So this is what often happens with appellate lawyers and unfortunately appellate judges. They put stuff into opinions and briefs that was never in the trial court, okay? There was never a chance to have it challenge evidentiary rules. There's no chance for voir dire, or as you call it in Texas, voir dire, right, to see if an expert is qualified. So basically, on the appeal, you don't know what's happened since what happened below. Now, one of the biggest offenders of this, the judge who I'm sure you're familiar with, is a judge named Richard Posner. And I've actually tiffed with him about this because he's very big about Googling, right? He's an appellate judge who Googles everything. And he has no problem putting stuff in the record that wasn't in below. I'll give you a really egregious example from Judge Posner. So there was one case involving a labor dispute where you had people who worked in a slaughterhouse, like a chicken processing plant, right? And part of their job was to have a 30-minute lunch break. They got 30 minutes for lunch. But the problem was they needed to take time to take off their protective gear and then go eat lunch and put the protective gear back on. And they claim that that ate up a big chunk of the lunch break, so they actually weren't getting 30 minutes, getting maybe 20, 25 minutes, whatever it is, right? So the trial court had some evidence on this, but Judge Posner didn't like it very much. You know what he did? He had his law clerks dress up in the protective gear and time them. See how long it took them to put it on. And he said, in his opinion, this is crazy. My law clerk said it took maybe 3 minutes to take the gear on and off, right? Okay. So I wrote about this. I blogged about it. I made a big fuss about it. Said, this is ridiculous, right? You can't have judicial fashion shows where they have in-chamber exercises. You can't check it. The lawyer who represented the workers emailed me. You know what he told me, which is interesting? The law clerks in chambers were not covered in chicken parts, right? When they put their gear on and off. They did not need to wash themselves and wash up all the chicken gear. And what else? In the factory where they work, there was only 2 sinks for like 50 men. And you know what? You have to wait in line for a sink. So it wasn't 3 or 4 minutes. It was like 5 or 10 minutes. This is the difficulty, right? And I made a big fuss about this and whatever. But this is the difficulty when you have judges finding facts on appeal. In fact, Judge Posner had an opinion last week where he cited Mayo Clinic and WebMD to discuss medical facts that weren't in the record either. Okay, whatever. So in this case, the Massachusetts Supreme Judicial Court did the right thing, right? They didn't know what the status was of the house, right? Is that Dominique? Dominique, what happens if Mr. Hickey, right, who we called stupid, right? What happens if Mr. Hickey has gone and bought a house somewhere else and doesn't really need the lot anymore? Do we really need to make Ms. Green sell it? What do you think? Oh, there would be damages, right? What would the damages be? Yeah, right? So let's imagine this, right? Let's imagine that, and then I think his point is well taken, it was an empty lot. He says, okay, I can't buy this empty lot, let me buy another one. And let's say that other empty lot he bought cost $20,000, right? Dominique, how much more did he have to spend because he didn't get the lot he wanted? 5,000, right? He wanted to spend 15, he had to buy some loads for 20. What do you think Mrs. Green would have to owe him in that case? Make him whole. I already said it. 5,000, right? Yeah. What are his damages? He wanted to spend 15, but he got stuck paying 20 for a different lot. Green can pay another $5,000. But Josh, why do you think it's not necessary to force Green to convey the land in this situation? What we call specific performance, right? If you remember, specific performance is where you make someone sell something or actually do something. And the law does not like specific performance because people shouldn't be forced to do stuff. Josh, why do you think specific performance may not be appropriate in this case? No, the hypothetical I just explained, right? Where Hickey's living somewhere else. No. The situation's this, right? After this entire court case happened, Hickey bought a lot somewhere else for $20,000. Should we make Ms. Green also sell him the lot? No. We're talking about equity here, right? Should we make her sell the lot if he's already living somewhere else? Why not? What's the point, right? If you already found somewhere else to live, why are we going to make Ms. Green sell the lot? I want to understand that. The Court of Appeals doesn't know what's happened below. Maybe for all we know that Mr. Hickey's been living in a hotel for the last 3 years, right? And is like so intent on having this specific piece of land. But if he just went and bought something else, Josh, what's the easier measure of damages? Yeah, what the difference was, $5,000 that Dominic said a minute ago. Right? So the Court of Appeals doesn't order Ms. Green to sell the land, even though that's what they effectively want. They say, send this back to the trial court and let's figure out what's going on. Where is Mr. Green living and how's everything going? No, there's no question. You did good. Thank you. You're done. Yeah.
I have a quick question about the Detrimental Reliance.
Yes, sir.
Did Mr. Hickey have to tell Ms. Green that he was detrimentally relying, or that he was selling his house in order to purchase her property?
Well,
is it just that he did?
So what made it egregious was that she knew, right? There's no obligation to tell someone that you're doing it, but the fact that she told him and she knew puts the detrimental reliance, right?
Even if it wasn't egregious, if she didn't know, it would still be as far as here property detrimental reliance.
Yeah, even if the lady, the seller, didn't know, it would still be detrimental reliance. Although, equity is always a balancing game, right? And the fact that she knew and sold to someone else anyway makes her have a really bad reputation, makes her look bad. And when we talk about equity, if someone looks bad, they're probably going to lose, right? Anytime you have an equitable case, if you have someone who knew and did it anyway, they're probably going to lose. Questions on that? Let's take a look at the questions on 575. And this is perhaps to speak to Spencer's question a moment ago. These cases don't always turn out the same way. When you're dealing with equity, things often go in different ways. So they mentioned this one case from Kansas, Walker versus Ireton, right? Where someone promises to buy a farm for $30,000, right? And then famous last words, oh no, we don't need to put this in money. Trust me, I'm an honest guy, right? If you ever see this, you demand it to be in writing because that means you're about to be a crook. Unsurprisingly, they hand in the check. They never cash it and they back out. In this case, the court did not award specific performance because they found it wasn't equitable enough, right? The check wasn't signed, wasn't within the statute of frauds. Too bad. So the same case, basically, with different judges, has different equitable outcomes. Okay. Let's take a look at the second problem number 2, right? O owns Blackacre and gives us a gift, the deed. Okay. And then someone says, oh, wait a minute, this land is yours again. I'll give it back to you. Let's see. Is that Sam?
Yes, sir.
Sam, if I say to you, I'm giving you this land orally, is that sufficient to convey the land? Why not? Yeah. An oral communication is not sufficient to actually transfer or revoke land. Okay? Okay. All right, any questions? No? Well, thank you very much. I see all of you on Wednesday.